so much. That was a very warm introduction, and I'm really thrilled to be here. I want to thank Jason for this invitation, which came some time ago. I think there were various things that led to this culminating, exciting event happening today. So let me start by saying that I'm really excited that I have students in the audience. I'm going to expect and hope that you'll ask me a lot of questions. And you'll also be prepared in case you don't. I'll just start asking you. So as we go, maybe you want to get out ahead of that. I'm going to be talking to you about tort liability and insurance. I might try to keep my remarks even a little shorter, just so we have some time for some back and forth to make sure this is of interest to you. I have a little bit of an agenda here, just to tie myself to the mast, make sure we get through all of this. Basically, I want to make two overriding points, takeaways. The first one is to convince you as a descriptive matter that liability insurance plays a really outsized role in the development of tort liability. I'm going to be somewhat myopic, although I want to learn from this experience. So we're going to be focusing on my research in the United States, but I think there's some relevance across the border as well here. So that's the first takeaway, just as a descriptive matter, that liability insurance plays this outsized role in the entire life cycle of a tort. So I'm going to talk about things like how it drives who sues whom, how it drives whether cases settle or are appealed. I'm going to try to convince you by the end that that the liability insurer is in many cases the real party in interest. Right? We think obsessively maybe in law school as we read appellate cases that we have plaintiffs and defendants, but kind of just off center in most cases there's a liability insurer. It plays a huge role. And the second takeaway is going to be more normative. What I'm going to try to convince you is that the insurability of a risk should play a driving role in, as a normative matter, right, prescriptively, should actually affect whether courts decide to extend tort law duties or to retract them. So I want to do both of those things in the space of relatively short amount of time. So first, liability insurance in the life cycle of a tort claim. Then I'm going to talk about liability insurance and tort doctrine. By this I'm meaning that we're going to look at some seminal cases in which insurability of the risk isn't just happening off screen, it's front and center, right? The courts in their reasoning are talking about it at the very juncture where they're encountering whether or not to impose a new duty to take care. I'm going to use as a case study a kind of cutting edge issue, at least in the United States, the take-home asbestos issue. This has to do with whether employers have a duty to take care not only to protect their employees who are working in conditions where they get asbestos fibers in their clothing and their tools, but when they then go home, that they spread this to family members and to others. That's what we're going to use as a case study. I'm going to pause for a bit and talk about why I think some of what we've encountered, and when I say we, I should have started with, a lot of this is taken from joint work that I did with Ken Abraham, who's a insurance and tort law guru from UVA, and we wrote an article together called The Glaring Gap in Tort Theory, very either provocatively or with a lot of hubris, right? The glaring gap in tort theory, where we're trying to put forward some of these views. So I'm going to talk about what our findings maybe have to say to tort theorists, and then I'm going to talk about what our findings have to say to actual judges. So I think that our ambitions in our piece and my ambitions today are pretty high. We want to say something of relevance that is descriptively really important. Then we have some normative ideas of how we should think about both theory and practice of tort law. So that's a lot to stake out, and you all will punch all the holes and critiques of everything that I'm going to put forward here. So let's get started. First with liability insurance in the life cycle of a tort claim. So we make the claim, and I think it's fairly well supported empirically, that when you look at certain cases and you wonder, why does an individual sue another individual? Let's just talk about individuals or businesses suing individuals, and then we'll talk about suing businesses. They only sue individuals who have some kind of insurance that would be covering the relevant tort at issue. There's almost no actual litigation or settlements outside of a few narrow exceptions where a plaintiff's attorney is going to take on a case against an individual where their actions aren't covered by something like a homeowner's insurance policy, a renter's insurance policy, or the like. When it comes to businesses, there are some select, particularly very large companies, like pharmaceutical companies come to mind, that are either self-insured, but primarily when we think even in businesses about smaller businesses, they too are covered by liability insurance. And in our paper, we go through, actually there's not great empirical data on precisely what component of businesses, large businesses, self-insure, et cetera. But in our paper, we go through some, I won't just say seat of the pants, it's a little more than that, but a little more rigorous than seat of the pants, looking at existing data and making some assumptions, and come to a figure that about 80 to 85% of all tort litigation in the United States involves liability insurance. 100% against individuals, and a little bit less against businesses. So that's really important in terms of decisions to file tort claims. But then, most people recognize that, at least in the United States, most people recognize that. When there are automobile accidents, the first thing that happens is that insurance is shared between parties. When a plaintiff's attorney is thinking about taking on a case in discovery, they'll find out if there's a homeowner's insurance policy or something that might cover it. What's less recognized, I think, is the role that insurers are playing pre-trial and trial through both their duty to defend and their right to settle cases. So insurance companies have not only the privilege to settle cases, they have the right. They can settle cases over the objection in almost every case of the actual defendant in a case, and they are making strategic decisions about which types of cases they allow to go forward and whether or not they will take into account the development of tort law, whether, for example, they're facing the prospect that a court might impose a new kind of duty in a certain situation and they would rather not allow the court to have that opportunity or to do so. So they are front and center, and they're making all sorts of decisions in how the case is going forward, as well as whether it gets settled or taken on to appeal. In the appellate process, this is really important, and there are a lot of examples of this. One comes to mind, not in our paper, but a separate line of research. I'm just going to mention it because it's a really recent example that you might be aware of. Amazon, right, the very large online platform, has been sued increasingly in the United States, and there's a big issue about whether they should be held liable as a seller of goods or not. And I'm mentioning that because there's a whole lot of cases in which Amazon was prevailing. Courts were deciding that they were not a seller because they didn't transfer legal title of any of the goods that they're housing in their warehouse, etc. And then the dam broke, so to speak, in the mid-1990s. And interestingly, Amazon realized that while they might prevail before federal courts, right, because in our system we have federal and state courts, and federal courts aren't really likely to get out ahead of where state law is on an issue. So this is like a cutting edge issue. Can we consider them a seller of a product? As soon as some of the federal courts started to certify the question, so there was a big case in the Third Circuit Court of Appeals where they certified the issue to the Pennsylvania State Supreme Court, and at that very moment, before the court could answer the question, the case gets settled, right? So Amazon and their insurer were strategically kind of controlling the evolution of tort liability for some time by doing that. Okay. Whoa, that's not good. Oh, that's better. Here we go. Pause. Okay. Forms of tort liability. So there's actually pretty good empirical evidence in the U.S. that takes this data from the largest jurisdictions across all of the states and looks at what kinds of liability do we actually see going to trial. And as you can see here, let's see if I can do this. I don't know if anyone, can see this little red pointer. I just wanted to do it because I've never used it before. So you can see that 60% are auto liability cases. So like a lot of tort litigation today is still automobile liability. And then there's 17% up here for premises liability. There's some component for medical malpractice, property damage. This is really designed to show you that the vast majority of forms of tort liability, and this is against both individuals and businesses and entities, is in categories that are going to be covered by liability insurance. This comes to some of our calculations where we try to mete out the percentages for individual tort costs and for commercial tort costs. And as you can see, we account for this 47 in billions of dollars for the large entities that have kind of self-insurance. But this is where we're getting our 80 to 85% of all tort claims are covered by insurance. So that's the first point. It's a really big component of all this. Now I'm going to pivot and talk about something that's a little less well known, at least in the US, right? If you talk to tort professors, we're going to get in a minute about kind of some of our theoretical debates and wrangling amongst one another about whether this matters. But just as a descriptive matter, most tort professors, theorists in the US understand everything that I've just said, although maybe not exactly the scale of it, that liability insurance, in other words, really matters, kind of behind the scenes, so to speak. What's less well recognized, and what we spend a lot of time in the article doing in one section, is surfacing the number of times within actual tort doctrine, so state and federal cases in which courts explicitly talk about insurability in their decisions about whether to impose tort duties or not. Now there's a very famous case. You guys know Rowland versus Christian? Very famous in the US. You guys study that here? No? All right, so I'll tell you a little bit about it. Rowland is a case where an individual is renting an apartment. She invites her friend over to the apartment. Unfortunately, she's left her bathroom faucet in a kind of state of disrepair. She told her landlord that it was in this bad situation, but she didn't tell her friend who came over, who goes into the bathroom, uses the faucet, and gets sliced. You know, his hand gets sliced. So it's bad, it's unfortunate, and he sues her. So this is Rowland suing Christian. So when I teach my class, we get into the why do friends sue friends? And people have all sorts of answers, like because they get really angry, and sometimes you don't like your friends, and sometimes, you know, maybe your friends have a lot of money and you don't. But the answer to the question, why do friends sue friends, is because of liability insurance. This is an early case, actually, where notwithstanding the fact that in the United States, only roughly 40% of the population has renter's insurance, Nancy Christian had renter's insurance, and her friend knew that, and so the friend sued her, but knew that he wasn't kind of putting her assets up against the line, or wasn't going to drive her away. They were actually not feuding. They weren't in, you know, sometimes we read about cases, and behind the scenes you learn that it's about, you know, families of dramatically different socioeconomic status or origin who are feuding behind the scenes. No, these are actually friends suing friends. The California State Supreme Court, it's a famous case, though not because friends are suing friends. In the US, it comes about in the late 1960s, and the California State Supreme Court makes this momentous move. What's the momentous move? Before then, the duty that you owed someone as an owner or occupier of your land was based on their status as an entrant, right? There was the lowly trespasser, for whom you had to show no duty of care. Then there was a business invitee, who was the person who was on your property, like because you owned a store and they're coming to transact business. You owe them a heightened duty to make sure your premises are safe. And then there was the social guest or licensee. That's who the friend was here. And against that person, you owed like just a duty to make sure if there were latent or like hidden traps that you told them about them. So what the California State Supreme Court did is decide that those categories seemed very feudalistic, right? They seemed really like kind of hearkening back to an ugly part of both English and US history, where we treated people differently based on this kind of hierarchical, almost feudal status. They decided to have those three those three kind of classifications come crumbling down, and they were instead going to impose just a duty to take reasonable care against everyone, regardless of their status coming onto your land. And in the course of doing so, they articulated these 7 factors, right? You all have seen this, I'm sure, right? Especially in the US, we're sort of obsessed. Usually they're like 3-factor tests, but in torts, sometimes we get 6, 7-factor tests. So this is the California State Supreme Court saying all of these things are relevant to whether or not we should impose a duty to take care, in particular, a duty to take kind of affirmative care when you're the owner or occupier of a land. And as you can see, let me come back to my little red thing. I'm gonna overuse it, since as I said, this is the first time I've used the red thing. But some of these factors, are familiar to tort scholars, like foreseeability of the harm to the plaintiff, right? Foreseeability seems to be all over the place in terms of when do we impose a duty to take care. You have to think about, is the harm, if you don't take care, foreseeable or likely to occur? Then we have things like, let's skip down to this one because I'm going to come back to it. The moral blame, right? Is tort law really all about morality and wrong? So if the defendant has done something morally blameworthy, then we're going to impose a kind of duty to take care. This one you're going to see, it was already alluded to that yes, I did study economics before coming to law, and yes, I am very taken with a kind of deterrence-based prevention of harm view of tort law. We'll come back to that. But this one, just to show I'm not just making it up, this is the court saying the policy of preventing future harm. So if you can impose a duty to take care on the defendant, and you do so because by doing that, the defendant is going to be incentivized to take care and to avert or to mitigate harms down the road, that would be a reason to do so. And then this one, they're thinking about costs and benefits, whether or not the cost of the defendant would be too high compared to the benefits of relieving in terms of accidents averted, what's going on in the community. But it's like you have to make it all the way down the list to number 7, availability, cost, and prevalence of insurance for the risk involved. And I'm being only somewhat facetious to say that at the start of this project, it sort of seemed like tort scholars, theorists, students got kind of tired, right? After they made it all the way through like number 6 maybe. There's lots of fighting that we're going to come back to about morality-based views of tort law versus law and economics incentives. But like everyone forgot about, I think, the prevalence of insurance and being front and center, not in the background, not just off screen, like being a reason why you would or wouldn't impose tort duties. And so one of the things that we do in this article, and I'm not going to go through all of this, if you're interested, you could see it's not just Roland, and it's not just in premises liability cases, but there are a lot of premises liability cases, by the way, that come after, in which the courts do talk a lot about insurability of the risk. But there are a lot of areas of the law. Products liability is a big one. When our courts are imposing what we call a risk utility test, looking at the features of a product and deciding whether the risks outweigh the benefits, one of the factors that many of the courts look at is insurability of the risk as a reason for imposing liability. There's also a huge area of the law that was fascinating to me. I knew, although it was in our torts casebook, I knew remarkably little until diving in over the summer to the world of immunities. So the world of like intra-family immunities, charitable immunities, governmental immunities. In the US, as courts started to chip away, so for example, in the past, spouses could not sue one another in tort, family members couldn't sue family members, you couldn't sue a charity, etc. As courts started to chip away at those immunities, one of the big reasons why was liability insurance. So there are really striking statements, for example, about, for example, a son who happens to be working for his contractor father, who gets injured negligently, and he wants to sue, that, all of these quaint ideas of how immunity protects sort of family harmony go out the window when we have liability insurance, because the reality is the father is not going to be paying out of pocket. The liability insurance that he has as an employer is going to be providing recovery, and in fact, marital harmony, family harmony, all these things might be exacerbated if you don't let individuals sue. So it actually kind of turns that rationale on its head. Okay, so that's some other of the areas where we've traced this. There are, there are places where you can see this surfacing as well in things like the restatement, right? You all, I think, know that in the US we have these restatements of tort law that are non-binding, but allegedly persuasive statements of what majority principles of tort law would be. Erica alluded to, I've served as an advisor on actually 2 projects. One is finished, it's called the Liability for Economic Harms, and one is ongoing on remedies. And these, we might talk about a little bit in the Q&A. It's like allowed me to kind of see how the sausage is made a little bit. These meetings are kind of phenomenally interesting, at least for a while. They go on too long, but I should say only positive things, especially since I'm being recorded. But they have judges and academics and practitioners who come together and debate all of these kinds of principles. So for example, in the second restatement of torts on, that was addressing strict products liability, they talked explicitly about the idea that public policy would demand putting the burden of accidental injuries caused by products onto the entities that market them and can be treated as a cost of production against which liability insurance can be obtained. So one of the driving underlying theoretical justifications for the imposition of strict products liability on manufacturers had to do with their ability to get liability insurance. And it's front and center there too, even though again, I think often ignored. And here too is just a statement that preceded the second restatement, strict products liability, where Justice Traynor was arguing in a very famous concurrence for why we should impose strict liability, saying in essence the same thing, that here we shouldn't put this burden on people who are injured, who might suffer an overwhelming misfortune. Instead, we should put liability on the party that not only is best situated to avert the harm, but also can obtain liability insurance. Okay, let's go to our case example and speed things along. So this is a California State Supreme Court case. As I mentioned, it deals with whether or not the highest state Supreme Court in California should recognize what was a new duty. Right? The new duty is whether there should be a duty of care in these take-home asbestos exposures. Right? So should the employer's duty go beyond just protecting its employees at the place of employment, but should it cover these horrific situations actually where employees are coming home with asbestos fibers all over their clothing and tools and the like, and then it's getting onto family members and then other people out into the community who then suffer harms from these asbestos fibers. Okay, so the state Supreme Court here says that, finds that there is a duty of care. Here's the articulation, right? There's a duty of care to protect employees' household members from exposure to asbestos through off-site contact with employees who carry these fibers home on their work, clothing, tools, vehicles, or persons. Now, in the course of getting to that determination, I'm going to argue that liability insurance played a key, not the only. The whole point of this talk isn't to convince you that liability insurance is the only factor that should move courts, but it played a key role in moving the California State Supreme Court to take this position. So, and they also, I would argue, are taking what Guido Calabresi called the cheapest cost avoider approach. Right? Guido Calabresi is sort of one of the founders of this deterrence-based tort view that says we should put liability on the party who can most readily take measures to avert the harm from happening. Again, I hope we get into a discussion about this. I am firmly of the view that notwithstanding the fact that corrective justice or civil recourse might have captured the public's imagination and with terms like justice seem to be like on the side of good, I am firmly committed to the principle that if we could induce parties to take optimal levels of care so that they avoid harming people, we do more justice, right? Justice is actually, in my opinion, on the side of a deterrence-based view of tort law. Far better, right, to do justice to the legions of people that you will not harm if you can figure out how to avoid these kinds of accidents than only worrying ex post about how to do justice between the two parties. That's my view. And again, I know it's a debatable proposition. The court here takes the premise that employers and premises owners are generally better positioned than their employees or members of the household to know of the dangers of this asbestos and to take reasonable precautions to avoid injuries, right? So I'm going to term that. I think that's a court taking very much a kind of cheapest cost avoider principle. If we impose this liability on the employers, they will be incentivized to do something about it so that they take precautions. Maybe all the employees have to leave absolutely everything, and I don't know the technical solutions here, but maybe take certain types of showers, etc., before going home so that they don't transmit this. Now, the relevance of liability insurance. So this is an interesting case because the relevance of liability insurance kind of surfaced to the court. The parties were arguing about it, and the defendants wanted to say that actually today in the United States, or circa 2016 when this case was decided, that there's no insurance coverage for asbestos, that bankrupt all sorts of entities, now there's no insurance coverage. And the court didn't fall for that. They said that the relevance of really what was available at the time of the exposure, right? So we're going to look at that and decide whether that's relevant or not. And in general, the court didn't buy the argument that the defense put forward that this take-home asbestos was not an insurable risk. And here's one of the things the court said. They said they don't really see why it presents greater uncertainty than, say, negligent release of chemicals or negligent contamination of groundwater, all of which they said, the insurance companies had readily figured out a way how to actuarially decide and price the certain types of risks. Okay. So interestingly, though, so now I'm going to move for a minute to say, sometimes people say, oh, well, if you buy this argument, then insurability will always be in the direction of increasing or expanding tort duties, right? So the Kessner court is saying, well, we don't buy that this is an area where the uncertainties are so great, the information demands are so great that we couldn't possibly have insurance companies able to insure the risk. But it turns out, and this is also in the case, that there's an interesting way in which insurability can both expand, as it did in this case, to a new duty to protect against harms that arise from take-home of the asbestos, but at the same time limit or cabin those liabilities. So here, the court explicitly limited the extent to household members and didn't apply it to those, with whom people in the household were enacting in the general community, where they actually were also spreading the fibers and the risks more so. And the court did this by saying that here they were mindful that this would both invite a massive litigation, but it would also impose uncertain and potentially massive and uninsurable burdens. So again, this insurability rears its head to potentially put a brake on at least how far we're going to expand this tort duty. And interestingly, we explore this a bit in the paper, this automatically made me remember a different line of jurisprudence that we study in the US called the imposition of negligent infliction of emotional distress. So in the US, at least, it was only recently, fairly recently in tort law history, that courts imposed a freestanding duty to protect against negligent infliction of emotional distress. Right? So not physical injury or property damage, things that were mental distress and the like. And interestingly, while the courts decided in this line of jurisprudence to impose duties to take care to prevent against emotional distress on the part of entities, once they started to do so, actually the insurance companies didn't expand their policies. And there's some uncertainty as to why they didn't do that, but they didn't expand policies to cover that. They determined that it wasn't really an insurable risk. And you can trace in the US that after the courts seemed to impose this very broad duty to take care to not impose emotional distress onto members of society, they then kind of retracted and came up with these certain categories where they would and wouldn't recognize negligent infliction of emotional distress. And one of the reasons that they limited this is because they were worried that it would be impossible to insure such risks. So again, it's the same story, not in the take-home asbestos line, but in negligent infliction of emotional distress, where Professor Abraham and I would argue, at least, you can't understand the evolution of tort doctrine and its shape and how it morphs over time without understanding its interaction with liability insurance. Okay, let's talk about tort theory for a minute. I'll let you look, it's good, I'll let you look on the screen at like the loaded responses that we have to theorists while I tell you what their affirmative case against our position would be. So in tort theory, in the US at least, there are kind of two primary camps. There are different articulations, and there's some who argue that we're being under-inclusive by saying there are two primary camps. But for now, let's just say there's the corrective justice, civil recourse camp, and the kind of deterrence, law and economics inspired camp. Now, in our article, we suggest that all camps, that tort scholars of all theoretical and methodological stripes have underappreciated the role of liability insurance, and that they should take note of it. But truth be told, right, the civil recourse corrective justice scholars are kind of under more intense scrutiny by us. Why so? Well, at the basis of those theories are the idea that the purpose of tort law, or what tort law is accomplishing, even if like love, it doesn't have a purpose, what it's doing is it's doing justice between the parties, right? It's righting wrongs. There's either an articulation of finding moral wrongs that are being corrected, or in civil recourse terms, where Ben Zapersky and John Goldberg have kind of formulated this theory whereby it's not moral wrongs, but it's still legal wrongs. The idea of tort law is very focused on correcting or righting these wrongs, and it's a very bipolar situation, right? You look, all you need to do is look at the parties before you. You're not going to look to outside exogenous things. Liability insurance is, to our mind, wrongly conceived of as kind of exogenous to the tort law system. It's like wealth of the parties. It's like a lot of other things that shouldn't determine the court's decision about whether they impose a duty on a particular party. We have two things that we say, although really what we want to do is kind of smoke out responses from those theorists, because neither of us is a corrective justice or civil recourse, although it's like many of my friends are. I spend a lot of time in New York, and we have like a tort theory workshop, and we bring everyone in of all different theoretical and methodological stripes. So I'm interested and I try, I just don't want to be the I'm not the best defender of those theories. But we have two thoughts. The first is, and this is a pretty strong form claim that we make, but we make a claim that the specific wrongs in tort law, and if you take a historical perspective, as we have, and try to trace this through time, that the specific quote-unquote wrongs that are subject to liability are only in play because those are things that have been insured. So, we think that even if you want to have a theory about tort wrongs, the nature of those wrongs would look very different in the US absent liability insurance. We talk in the paper about a whole bunch of tort doctrines. I'll mention just a few. Think about, like, in the US we have this thin skull rule or eggshell skull rule that basically says that even if a defendant is only the smallest amount negligent, but injures a person who entirely falls apart and has dramatically high damages, that defendant is responsible for the full course of those damages. We make the claim that a rule like that would never have persisted absent liability insurance. No way. We might have other ways that we would deal with it. We might have other kinds of ways in which we gradate damages based on percentage fault. Everyone's aware for comparative fault, we do that when we split across the plaintiff who's somewhat negligent and the defendant. But we're talking about, imagine a plaintiff who's in no way, shape, or form responsible, but just has a defendant who's momentarily negligent, like takes their eyes off the wheels for 1 second, the way empirically it turns out probably the vast majority of drivers, including very cautious drivers, do, versus someone who's done something egregiously reckless, right? They're facing dramatically different consequences. The second thing that we talk about is that it kind of mystifies us a little bit that there's as much resistance, particularly from civil recourse scholars, about our main claim here about liability insurance, because the way we see things, the presence of liability insurance only enhances access to the courts, right? So absent liability insurance, we worry that there's a lot of individuals who don't come to court at all, right? So there's a lot of ways in which liability insurance actually kind of greases the wheel of this ability of individuals to come and press their rights before courts. On the law and economics deterrence side, here we can't fault all scholars for never having thought about liability insurance or not taking it into account. But of course, we still want to press, because we're scholars and we like to be provocative, we want to press the point that almost no one before has taken into account doctrinally the numbers of cases in which courts, kind of ahead of the scholars, are wrestling with the question of how liability insurance should or shouldn't matter, including whether liability insurance will tamp down on deterrence, right? There's the so-called moral hazard problem, which has nothing to do with morality and everything to do with economics. So it's a little bit confusing, but the moral hazard problem is if I'm a defendant and I have liability insurance, then I'm gonna maybe not take as much care because it's not my personal assets that are gonna be on the line. And maybe that will actually, in the extreme, if it's things that I fully am controlling, whether to engage in an activity or not, that would mean that it wouldn't even be insurable, that the moral hazard would be so great. So take something like arson. Again, we might have moral qualms about allowing me to get out insurance to go around setting buildings on fire, but there's also an economic reason we can't do that, because it's not an insurable risk, because I'm intentionally deciding whether to set things on fire. It's not like a risk-based decision that insurers could price. But we talk about a variety of measures in which actually liability insurance seems to be combating moral hazard. There's a lot of sophisticated ways in which insurance, liability insurance, is not just spreading losses, but it's doing risk management. It actually is aggregating information, and in a lot of new areas, think about things like data breaches, security breaches. There are insurance companies that are figuring out protocols and ways to actually avert or minimize harms because they have sufficient information to be able to do so. And there's also all sorts of ways where they can do risk pricing, where they can increase premia on individuals who have not shown that they are taking care in their previous track record, and they therefore can not only risk price that way, but insurance premiums can serve as like notice to individuals about areas where they might be able to take further measures to reduce harms. Okay. Let's just end. I said I wanted to make sure there was time for questions to move from theory to the courtroom. So interestingly, this is a paper that suggests actually that judges might be out ahead of scholars in terms of thinking about these issues in really hard, cutting-edge kinds of questions, like the take on asbestos. But we, of course, need to point fingers at everyone in this piece. So we do point some fingers at judges, and we kind of have three different categories that we've divided cases into. So the kind that make us nervous or upset are cases where judges, so one category is judges actually have good empirical evidence about insurability of a risk, and they're surfacing it and discussing it, and that's all well and good. The other categories are places where they don't have any good information in the appellate record about the insurability of a risk, and they're just making it up, right? It's just like assumptions, speculations, some of which are very off base. And here's where having especially Professor Abraham at my side, who's really, like the preeminent, one of the preeminent insurance law scholars in the US, we could kind of look and see in those cases where the courts were just making assumptions about what kinds of risks were or weren't insurable in particular cases, they seemed off base or not. And then the final category are where cases, or where courts surface this as a factor they should be looking at and say, we don't have any evidence about it, so I guess it's like neutral, we just make nothing of it. And those ones are kind of screaming out, those two latter categories in our mind, for parties to get this record evidence before courts. So that's where we end the piece, is by arguing, here's the piece, the glaring gap in tort theory. We say boldly, we think it was, and it is a mistake for courts to rule out express consideration of liability insurance in making their decisions. We say that candor requires more open acknowledgement. So a lot of these cases, we're pretty convinced it's happening behind the scenes. This is the part that's fun. Having written the paper, we've heard now from only a smattering, but some judges, and it's actually really interesting that we've heard, for example, from one judge who said, I'm so glad you wrote that piece. In every single tort case, I have to educate my panel about how liability insurance works and what's going on in the case. Well, that seems good, except to think about, wait, none of this is in the appellate record evidence. I'm not sure even the best of our judges are all sort of insurance law experts and could satisfy that rule. We also think that they'll come to more sensible decision making because it will be based on more accurate information. Okay, I think I'm going to stop there because I want to make sure I hear from you. This slide was just going to suggest that there are some problems here, the problems, all the way through with our piece, but there are some particular problems when it comes to what we argue for the courts. We're very careful to say, in the US at least, we're not saying this information should go before the jury. Right? We have juries in almost all tort cases, and there's specific reasons why you might not want that information before the jury. But that shouldn't be the reason that you preclude it from going to the courts. But there's some worries, for example, that we'll just have like a battle of the experts over insurability. One commentator could say this to Professor Abraham, but not me, that this is just like a full employment. This is a call for full employment of insurance law experts, right? To be fully employed to be doing this before the courts. But we think it's worth at least debating. And I'm going to end there and ask for questions and comments.